At the Global South Network, we are deeply committed to promoting interdisciplinary and cross-regional conversation. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? You came upon a series of lush islands with white sands, beaches that are caressed by warm turquoise blue water. But what did they do? They enjoyed the bliss and exploited the people and land for their own benefit. For locals and for commentators from the global south in the Caribbean, colonized, first of course the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane, cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the sea and through the surf that these colonizers came in their boat, landed on the Caribbean's pristine sand beaches, turned their turquoise waters, their Caribbean seas red with the blood of so many innocents. However, not only were people and lands and resources colonized and exploited, and the point of today's talk is about fact and colonizations of our legal imagination has also been an enduring legacy of colonial history of Caribbean people. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imagination? Have we been developing a truly Caribbean jurisprudence? There can be no social jurisprudence separated from social context. And so social context is critical to this idea of a Caribbean jurisprudence.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riyad.
Dr. Nauman Riyad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riyad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
In the governance model that the written constitutions have brought into being, there is again there's this tension. There's a tension between the executive's responsibility, three branches of government model, executive responsibility to lead policy and also lead the legislative agenda in Parliament. The Parliament is supposed to be passing the laws, and in the classic British model, judges are not supposed to be saying a law is to be struck down. They're supposed to be interpreting and applying, in some senses, and sometimes clarifying. All right. The model that has been developed in Caribbean constitutionalism is a model that is necessarily developmental with impact for society and social and economic policy. Why? Because when the executive brings forward a policy and embodies it in law, then the courts have a constitutional power and duty to, if it is found short of, for example, fundamental rights standards or separation of law standards or rule of law standards, to say to the executive and the legislature, well, you've missed the mark a little bit. You know, you overreached a little bit. And it's this the tyranny of the majority point, right? It's, you know, the French writer writing in, I think in 1835 about American constitutionalism, and the idea that even though democracy is about majority rule, well, the majority can constitute a sort of a tyranny of the minority, and the courts are the ones who must now stand in the breach, as it were, and hold the tension. So how does it negotiate it? In answer specifically to the question, it negotiates it through the lenses of constitutional core principles, values, and standards, including human rights standards, but not limited to human rights standards because of something called the basic deep structure doctrine, which says there are certain core constitutional principles which are inviolable: separation of powers. You can't get involved in sentencing, for example. Rule of law, which we kind of understand, the protection of the law, and so on. So that's how it negotiates that tension and space between the three branches of government. But the courts have the final arbiters, actually, of even socioeconomic policy.